My name is Greg Kimball. I'm the Director of Public Services and Outreach here at the Library of Virginia. It is my pleasure to welcome you here tonight on behalf of the Librarian of Virginia, Sandra G. Treadway. As many of you know, the library is the oldest historical institution in the Commonwealth. We'll be celebrating our 200th anniversary of our founding by statute next year. Our collections, of course, reach back much further. From the books that once lined the shelves of the original Colonial Council Library to the digital records of recent governors, the library stores, preserves, and makes accessible our state's rich legacy for generations to come. The library is honored to partner tonight with another indispensable historical organization. Preservation Virginia has made and continues to make critical contributions to the preservation and interpretation of the Commonwealth's built environment, the Marshall House, of course, being one of the great examples of that great stewardship that they offer. But just as important, Preservation Virginia has also pioneered important projects that ensure that Virginia's rich cultural landscape reflects the stories of diverse and often forgotten communities. And I'm honored tonight to introduce to you Mika Downey from Preservation Virginia to introduce our speaker tonight. Thank you for coming.
Thank you, Greg. I have had the pleasure of knowing him since I was an undergraduate, helping with my research here when I came. I'm Mika Downey, Education Coordinator for Preservation Virginia's Historic Sites. I think I met a lot of you just a little bit ago at John Marshall House, just across the street. Thank you so much for being here today. Gerard N. Magliocca is the Samuel R. Rosen Professor at the Indiana University Robert H. McKinney School of Law. Professor Magliocca is the author of 4 books and over 30 articles of constitutional law and intellectual property. He received his undergraduate degree from Stanford, his law degree from Yale, and joined the faculty after 2 years as an attorney at Covington and Burling and 1 year as a law clerk for Judge Guido Calabrese on the United States Court of Appeals for the Second Circuit. In 2014, Professor Magliocca received the Indiana University Trustees Teaching Award. And at Indiana, he teaches courses in torts, constitutional law, intellectual property, legal history, and admiralty. From 2019 to 2021, Professor Magliocca was a fellow at the Washington Library at Mount Vernon, where he researched his new biography on Justice Bushrod Washington. In 2021, he appeared in Amend, The Fight for America, a Netflix series on the 14th Amendment. Some of his other publications include The Heart of the Constitution, How the Bill of Rights Became the Bill of Rights, American Founding Son, John Bingham and the Invention of the 14th Amendment, and Andrew Jackson and the Constitution, The Rise and Fall of Generational Regimes. Tonight, however, Professor Magliocca will be speaking about his newly released biography of Justice Bushrod Washington, who served on the Supreme Court with John Marshall from 1801 to 1829. In Washington's Heir, The Life of Bushrod Washington, Magliocca draws on his research as a fellow from the Washington Library at Mount Vernon to tell the story of Justice Washington, through which new perspectives on George Washington and Chief Justice John Marshall emerge. He uses Washington's journals to reveal new information on some of early America's landmark constitutional cases, as well as examining the inheritance of both Mount Vernon and of the enslaved people of the Washington family. So thank you so much for being here. It's my pleasure to get to know Gerard. So I'll welcome him.
Thank you, Mika. Can everyone hear me all right? Mm-hmm. Oh, excellent. Well, listen, thank you to everyone at John Marshall House and at the Library of Virginia for putting this together and for inviting me to a live event. This is the first real live event I have done for, well, much of anything that was outside of the classes that I teach since 2019. So I'm excited. I'm sure many of you are excited to be able to come out and do these sorts of things again. This is also my first time in Richmond. Which is kind of hard to believe given the kind of research that I do. I had planned to do some visits that were closed down by the pandemic, but well, I finally made it and finally got an opportunity to see John Marshall House. And you know, for someone who does the kind of work that I do, being able to do an event in the home itself, and in a home and a place where the subject of my new book would have been many times during his life is a pretty special kind of occasion, and I'm really quite thrilled to be here and have had the chance to do that. My book is on Bushrod Washington, as Mika mentioned, and I just want to explain briefly, who he was and why I decided to write a book about him. He was George Washington's nephew and heir. He inherited Mount Vernon upon Martha Washington's death and lived there until his own death in 1829. He also served on the Supreme Court, as Mika mentioned, from 1798 until 1829, and was a close collaborator with John Marshall during a very important period in the development of the Supreme Court. So there are a couple of reasons why I decided to write this book. There's a famous story, about David McCulloch being asked why did he write a particular book, and his answer was, because I wanted to read it. And the only way to do that is to write it. So that's part of the answer here. But first of all, it's no one had ever written a book about Justice Washington before. Secondly, it's a way of telling the story of George Washington in a somewhat different way, because you're looking at him from another angle. It's a way of telling a story about John Marshall in a different way because of the vantage point that Bushrod brought to their relationship. And there are also a lot of aspects of his life at Mount Vernon and his personal life that I found interesting. But what I'm going to talk about today is Washington's relationship with John Marshall. And a couple of reasons for that. Obviously, one is we were just at John Marshall House. And secondly, a lot of their relationship developed here in Richmond. And so I thought, given the place, that would be an appropriate sort of way of framing this talk. Now, one reason that I'm very interested in the book about the relationship between Bushrod Washington and John Marshall is because of their work together on the Supreme Court. Now, a standard way of talking about the Supreme Court in this period is that it's the Marshall Court, and that means that John Marshall did everything. He wrote all the opinions. He got them to be all unanimous. He kind of single-handedly made the court into the powerful institution that we now know. That, if true, would set an impossibly high standard for future Chief Justices. It turns out, though, that it's not quite true, in that he had an important ally and partner in this work, and that was Bushrod Washington. And, I will talk a little bit about some of what they did on the court together, but the sort of bedrock or foundation for this relationship came in the work that they did before they reached the Supreme Court. Because they knew each other from a young age and worked together extensively before they were appointed to the court, which is almost unprecedented in the history of the Supreme Court. If you think about it, Supreme Court justices, however they manage to get there, usually don't know the others at all or know them only very slightly before they are forced, more or less, to work with them all the time for life, right? But that was not true for Washington and Marshall. They had a very different, independent kind of relationship. So let me talk a little bit about that. They meet when Washington is 18 years old, and they meet at William and Mary. At that time, George Wythe, one of the founding fathers, Jefferson's teacher, was a law professor at William and Mary. He was basically the first law professor in the United States, given this position by Jefferson, who was governor at the time. And Wythe developed a curriculum where he gave a series of lectures about the law and did other things that are now widely copied in law schools for the training of lawyers. And in 1780, Bushrod, who is 18 years old, arrives at William and Mary for really what is his only formal legal education or formal education of any sort. He had been tutored at home basically for his youth until he arrived at William and Mary. And one of his classmates in those lectures is John Marshall. And so that's where they first meet. They don't meet again for some years after that. They have very different sort of backgrounds, at least in terms of their, where they came from. Bushrod is the oldest son of George's favorite sibling, his brother Jack. Basically, Jack Washington is the only sibling that George Washington likes and confides in. And Jack Washington was the person who ran Mount Vernon when George was fighting in the French and Indian War. Jack Washington is the person who would have inherited Mount Vernon had George been killed in the French and Indian War. So basically, when Bushrod comes of age as an adult, George takes a special interest in him as the eldest son of his favorite brother. And shortly after the lectures that Bushrod attends at William and Mary, which is cut short by the British invasion of Virginia under Cornwallis, Bushrod comes to Philadelphia, and George arranges for Bushrod to have an apprenticeship with James Wilson, who is another of the founding fathers and was one of the leading lawyers in Pennsylvania. And it's really at this point in time that George begins to take an interest in Bushrod's career. Okay, so Bushrod does a 2-year stint in Philadelphia. Then he returns to Virginia to practice law. He also gets involved in politics. He is elected to the House of Delegates in 1787, and of course that is then brings him back to Richmond, and Marshall is also in the House of Delegates at that time. Then they are both elected as delegates to the ratifying convention for the Constitution, which is held not very far from here in 1788. Both Marshall and Washington support ratification of the Constitution. They are Federalists. We don't know a whole lot about what Bushrod was doing at that time. Marshall was a very active participant in the debates in the ratifying convention here. Bushrod less so, though he was busy writing letters to George, sort of keeping him informed about what was going on, because George Washington did not himself come to attend because he was kind of like the presumptive president, should the Constitution be ratified. Okay, this is Anne Blackburn, who is Bushrod Washington's wife. They marry in 1785. Her father had been an officer in under George Washington's command. Bushrod and Anne, or Nancy as he liked to call her, had no children of their own, though they did raise many of their nieces and nephews who were orphaned because of early deaths of some of their siblings. After the ratifying convention here in Richmond, Bushrod leaves politics and concentrates on his legal practice. At first, he's in Alexandria, but he doesn't find a whole lot of business there, and so he decides to move to Richmond in about 1792. And Richmond, of course, is the center of the legal world of Virginia as the state capital, but it's also kind of a really special place for legal talent at that point in time. Kind of almost like you could say a golden age of lawyers, or that it's hard to replicate in any other point in American history. Let me give you some examples. Okay, so Patrick Henry, now basically retired from politics, he is partnering sometimes with John Marshall on cases where basically Henry would do the jury arguments and Marshall would do the legal arguments to the court, right? Now that's a pretty dynamic team, right? And they were quite successful in a number of high-profile cases. All right, then we have Edmund Randolph, who was Attorney General for President Washington, and after serving for a time there, returned to Richmond to take up private practice, and of course became one of the leaders of the bar, as he had also been an important figure in the state prior to becoming Attorney General. Okay, then there's Edmund Pendleton, who is the head of the Virginia Supreme Court, which was called the Virginia Court of Appeals, another leading figure in the ratification convention here and in state politics and law for decades. Pendleton was an especial kind of inspiration to Washington and Marshall, in part because they argued in a great many cases before him and his court. Now, I mention these other names and these other figures because, notwithstanding all of this talent that's here at that time, Bushrod Washington rapidly, after his move here, is recognized as one of the 2 or 3 best lawyers in the state. So that says something about, what people thought of him and who he was sort of competing with. Now, mostly he was doing appeals, though he did other kinds of cases as well. And he also wrote two-volume work of reports on cases heard by, rather than Chief Justice, they called him President Pendleton. President Pendleton's court, and these included his own cases as well as cases that others were involved in. So basically, he was kind of a regular attendee of the court there and was, a very familiar figure to all of the judges of that court. This was one of the early efforts to kind of write down and keep careful records for other lawyers about decisions of a significant state court. Now, one reason for pointing this out is that President Pendleton had a practice whereby he tried, whenever possible, to have one opinion for the court in a case, which was very different from the practice in many other state courts where each judge would write an opinion in every case, or nearly every case, which meant you had a lot more opinions. It was a lot harder to understand what the court's decision was. This practice that Pendleton was keen on is one that then the Marshall Court adopted, basically on the sort of advice and support of the 2 Virginians who were ultimately on the court, John Marshall and Bushrod Washington. Okay, now it's in this period that Bushrod Washington and Marshall become close personal and professional friends and, you could say, competitors. Okay, so they argue against each other in a number of cases before the Virginia Court of Appeals. They also collaborate on cases sometimes. They also both are elected to the City Council of Richmond and serve together for a period of about a year or so, working on different committees dealing with issues like police reform and municipal finances and so on. They also socialize together. Now, basically for a period of about 3 years, Bushrod Washington and his wife lived between 7th and 8th Streets, and of course, Marshall's house is over here on 9th Street, or 8th and 9th Street, right, given the way the property was laid out then. They had a lot in common, both professionally and personally. Okay, so for example, they had both served in the military during the Revolutionary War, though Marshall for a far longer period of time. They were both Federalists, both in supporting the ratification of the Constitution and in their political views in this period. They both, of course, owned many people as slaves. And they both had wives who suffered from ill health in a way that often left them as caretakers for them. So, it's very hard to sort of go back and understand sort of the correct medical diagnosis for someone from 200 years ago, because the terms that people used at the time were very vague and often didn't have really anything to do with what was actually troubling them. But we know that Polly Ambler, who was Polly Ambler Marshall, this is in the house, by the way. We know that she suffered from what you might call depression, or what you might call, I mean, she was described in later years as an invalid, although again, like, it's not clear what that really means. And Nancy Washington suffered from very similar kinds of symptoms. Now, you know, that whether that's a coincidence or whether you could say that there's some reason why that might have happened, you know, given the sort of social, political, cultural situation at the time, it's hard to say. But what it did do is create something of an emotional bond between Washington and Marshall, in that they both spent a lot of their time as caretakers for their spouse. And that was kind of an unusual thing at the time, and probably, you know, deepened their kind of the sort of personal relationship that they had outside of their professional interests. Now, another kind of thing that they had in common was a close relationship with George Washington. Okay, now obviously in Bushrod's case, that was because of his blood relationship to George. In Marshall's case, it was because of his service under George during the Revolutionary War, as well as their political connections that developed over many years after that. George Washington also thought very highly of both Bushrod and Marshall. And the sort of one way of capturing that comes from a story, which is that in 1798, you know, Washington was in retirement at Mount Vernon, and he was very concerned about the drift of politics at that point. In particular, he didn't much care for Jefferson and Jefferson's views on various matters. So he decided that there had to be some Federalists recruited to run for the House of Representatives and get more Federalists in Congress. And he thought he had a great idea, which was to get Bushrod and Marshall to run for Congress from Virginia. So he summoned them to Mount Vernon and brought Bushrod into his study. Now, any of you who've been to Mount Vernon may know that the study was sort of like the special room that only, you know, people given access could enter, and George was supposed to be allowed to be there, you know, on his own, you know, to think and be, you know, have solitude, basically. So Bushrod goes in and George explains what he wants them to do. And Bushrod goes outside and Marshall is there, and he says, well, this is what he wants us to do. He wants us to run for Congress. And of course, they didn't want to run for Congress. They didn't want to run for Congress for a lot of reasons. First of all, it would have meant taking a big pay cut from their work as practicing lawyers. They didn't think they could win because they were going to be running against incumbent members of the House in Virginia who were supported by Jefferson, right? Which seemed like a tall order. Also, in Bushrod's case, he was a more introverted, bookish person who didn't really like politics in the way that Marshall did. So he was reticent for that reason as well. So they both discussed it, and they said, well, okay, we can't do this. So Marshall said to him, well, you have to go in there and talk him out of it, you know. Now, I should say, Marshall, when he was later in his life, had a different version of this story, which made his role seem much bigger. But this is the story that Bushrod Washington told to Martin Van Buren some years earlier, which has a greater ring of truth to it. So Bushrod goes back into the study, and he kind of says, you know, probably in a somewhat cautious way, why he thinks it's not such a great idea for the two men to run for the House of Representatives. And George listens to him, and at the end just says, Bushrod, it must be done. So Bushrod goes back outside and says to Marshall, look, he won't be talked out of it. We have to do it. So they decide to run. Marshall, of course, wins his campaign. Bushrod is bailed out of this need to run because there is a vacancy on the Supreme Court. Justice Wilson the same James Wilson that he had served as an apprentice in Philadelphia, was on the Supreme Court and died. President Adams decided that the vacancy had to go to someone from Virginia because there were no Supreme Court justices from Virginia, and Virginia was too important to be left out. So the Attorney General said to Adams, look, you have two choices. You can pick John Marshall or Bushrod Washington. They offered the seat to Marshall because he was the better known person, and he turned it down. But he said, Bushrod will be great, you should give it to him. And that is in fact what happened. Now, even before Marshall reaches the Supreme Court a couple of years later, Bushrod and Marshall are collaborating on other projects. First of all, after George Washington dies, they jointly advised Martha Washington on various issues. For example, things that come out of George's will, some details that have to be worked out, and most importantly, what to do with the enslaved people that George had wanted to free in his will. So many of you know, I think, that in George Washington's will, he said, those enslaved people that I have the power to free, I will free upon Martha's death, which created something of a problem. Well, what about in the interim between his death and her death? Because, of course, the people there knew that they would be free upon her death. They advised her, look, you should just free them, now, right? Why are, you're just going to create problems for yourself if you don't do that. So she followed their advice. Another thing that flowed out of George Washington's will was he gave his papers to Bushrod. And of course, he had amassed a very large collection of papers through his career. George Washington was a very meticulous man and kept very meticulous records. This naturally led to the thought of having a book, right, a kind of authorized biography. But Bushrod had a limitation in writing a book like that. He could only see out of one eye. So if you look at this portrait, this is painted of him when he was an older man. You see that the left eye is a little kind of not centered, right? He couldn't see out of that one. He suffered some illness when he was in his 30s. We don't really know. I talked to my optometrist about this, and we speculated on different things that could cause someone to go blind in one eye like that, but who knows? Anyway, so he basically wrote a letter to a friend saying, look, it would be too hard for me to write a book. It would just take too much time to just go through all that material. But I have a great idea for someone who can write the book, John Marshall, right? Now, they agreed to do that as partners. And they very much collaborated on what became the Life of Washington. There is an original edition of the 5 volumes of Life of Washington in John Marshall House. They thought they were going to make a lot of money from this. That didn't quite pan out because Marshall was, while he was very good at writing legal opinions, he wasn't as good at writing books. And it didn't sell as well as they had hoped. But, the collaboration on that book project, which went on for many years before Marshall was a Supreme Court justice and then after, shows, I think, kind of how they worked together. So, for example, Bushrod handled all of the business arrangements with the publisher and copyright and all that sort of thing. Bushrod was the copy editor for the book, so he wrote to their publisher at one point and said, "Look, I've gone to Richmond to be with Marshall, and we're going through every page of the next volume." And you can imagine whether they did it in the house or in the law office that Marshall had adjacent to the house. That the two of them working together, and Marshall would write him notes and say, in effect, like, hey, don't spare my feelings. If you think that something's not good, you got to tell me, because I really value your input. Washington also served as a kind of research assistant for Marshall. For example, they wanted to find out some things about the campaigns during the Revolutionary War. So Marshall said, well, why don't you write Alexander Hamilton, a letter and find out some of these things, because we don't know, right? So that's what Bushrod did. He wrote Hamilton a letter, hey, we're trying to figure out what happened in certain aspects of this campaign or that campaign. Can you fill us in? They worked on the visuals, maps, other things together. So it's tempting to think that this is how they collaborated on Supreme Court opinions. We don't know because we simply don't have records, say drafts or other things from the years in which they served together that could tell us exactly how the drafting process worked when Marshall put together his opinions for the court. Only very intermittently do we see a letter or something that tells us a little bit about this case or that case. But the work that they did on Life of Washington, which is the most well-documented, kind of shows the nature of their close collaborative relationship in writing. Now, parenthetically, many years later, Washington decided to do a revised edition of the books he had written when he was young about the Virginia Court of Appeals, and he asked Marshall, hey, can you go check out something? There's a record I need you to look up for me in Richmond about one of these cases. I just want to make sure I've got it correct. So Marshall, went down to wherever the records were and sort of got it out and looked at it. And I always thought it was really great if you could have John Marshall as your research assistant to sort of check out some facts for you in one of your books. So that was the kind of reciprocal relationship that they had. This kind of relationship that had been built up over many years, mostly here in Richmond, right, carried over to their work on the court in a number of ways. Now, this is not a law class, so I'm not going to, go into the minutia of that. But I'll highlight a few things that are sort of special about the relationship and the work that Washington and Marshall did together on the court. So the first is that in those days, Supreme Court justices spent a lot of their time conducting trials and hearing appeals in what was called circuit riding. So there weren't that many federal judges, so they would send the justices out to different parts of the country to be judges in ordinary cases and hold trials. Marshall's circuit was here in Richmond. That was the plum assignment because you basically didn't have to travel. I mean, he did sometimes have to go to North Carolina, but mostly he was able to be at home. And for example, this is where Aaron Burr's trial was as part of Marshall's circuit responsibilities. Washington's circuit was in Pennsylvania and New Jersey. They frequently would swap letters asking each other for advice about cases they had. Marshall would write a letter, hey, I have this issue, I've never really dealt with it before, can you help me? Or do you have any ideas about this? And Washington would do the same. Again, in a way that is sort of indicative of a kind of a close working relationship. They would also send each other summaries of cases that they had decided so the other would know what was going on. Second thing is, one thing that the Marshall Court was quite famous for was that the justices all lived together in a boarding house when the court was in session. And this was a way of kind of working out differences over wine at dinner, to discuss the case, get a unanimous opinion, and soothe any ruffled feelings that there might be. Washington was the one who was in charge of the boarding house arrangement. And as soon as he died, it ended, which would suggest that he was the one who really either initiated that idea or made it work. And a lot of people attribute a lot of the unanimity in the Marshall Court to the fact that they all lived together, socialized together, drank together, during the time that they were working there. I mean, one example of this is when the British burned Washington, D.C. during the War of 1812, the first letter that we have from Marshall writing from here was to Washington saying, you got to find us another boarding house. You know, we have to have a boarding house that we can all live in together. What are you going to do? You know, or like, tell me what you're doing. Washington, of course, did find them some accommodation. There's also a funny story in that, of course, the court at that time met in the Capitol, right? They didn't have their own building, and the Capitol was burned down, right? So where were they going to hear cases? So it turned out that they heard them for 2 years in a house that belonged to the clerk of the court. And they would just meet in the front parlor of the house, and there would be people standing outside, you know, kind of looking through the window to watch, right? And the clerk of the court who owned the house had, I think, 6 or 7 children who were young. They would come running in during the Supreme Court arguments. You know, they were playing whatever they were doing, and, you know, then they'd run out, and that was how the Supreme Court met, you know, for 2 years during this time. Washington performed other very important kind of informal functions within the court that were sort of as part of a handshake arrangement with Marshall. An example that I point out in the book is that some lawyer at one point writes Marshall a letter and says, look, I don't know if I can come to Washington to argue my case. Can I just submit my argument in writing? And Marshall responded, said, well, it's really up to Justice Washington, you know, because he keeps the records for us. So if he thinks it's all right, then fine. Now, that's, if you think about it, kind of an odd thing. I mean, Marshall was the Chief Justice, so what does he need Washington's approval, right? But it sort of shows that really, you know, as one of the justices said to Jefferson, you know, by the way, if you think that the Supreme Court justices, you know, sometimes leak or don't get along or whatever, that's been going on, you know, throughout American history. So there's nothing new. One of the Justice Washington and Chief Justice Marshall's colleagues wrote to Jefferson and essentially said that all of my colleagues, you know, and of course Jefferson was not a fan, right, of what the court was doing in these years. So one of the justices that Jefferson had appointed wrote a letter to him saying, oh, you know, this justice can't write, this justice is dim-witted, you know, and then he went through all of them, right? And then he got to the end and he said, well, and as you know, the other two, by which he meant Marshall and Washington, are commonly estimated as one judge, right? And of course, one way to view that is to say one judge meant Washington just did whatever Marshall said, right? But the more accurate way of looking at it, at least that's the conclusion I reached after going through my research, was that they were partners. They were equal partners, and you can trace that all the way back through their work here in Richmond. Now, there's a final sort of detail here, which I'll close on, which is Marshall was here in Richmond attending the Virginia Constitutional Convention in late 1829 when word reached him that Washington had died. He died while he was holding circuit court in Philadelphia. And, you know, Marshall's first reaction was he wrote a letter to Madison, who was also at the Virginia Convention, and he just said, look, I can't see anyone, you know how much I regret his loss. No, and then he wrote some things after that, you know, sort of explaining how important Washington was to the court and then to his own life. And that was the close of their relationship, or at least from Marshall's vantage point, the close of their relationship, which had flowered in Richmond, also ended in Richmond. So with that, I will happy to take any questions that you might have.
We would like to pass the microphone to people who ask questions, so we capture that because we are recording the talk. And I also want to say we have a book signing after the talk, so please also stay for that. Anyone has a question?
I know there were early on political parties developed. How factionalized was the court in the days of the Marshall tenure as Chief Justice?
So, at the beginning, not at all, because they were all Federalists, because they had all been appointed by George Washington and John Adams, right? So there was no factionalism at all. Now, okay, when Jefferson and Madison make their appointments, they are able to kind of still, for the most part, achieve a high degree of unanimity. Now, how did that happen? Okay, first, the fact that they all lived together in the boarding house and socialized together had something to do with it. Second, there was this practice that had developed where the Chief Justice would typically write the opinion, or the opinion would be issued in his name. And there was a strong culture that they developed, in part from what they had seen in Pendleton's court in Virginia, that you should speak with a single voice, even if you disagreed with the outcome. Now, sometimes they would kind of paper that over by saying, if you read the opinions carefully, it'll say something like, there's one opinion, and then it will say somewhere, majority of the justices, agree that, right? Which of course means, well, not all of them agree with it, but people didn't dissent. So unless you read it carefully, you'd think it was unanimous. The other thing to say about it is that, some of the appointees were simply persuaded, and they tried to work out opinions that were not leaning too far to one side or the other. There were compromise elements in it. Sometimes that's more obvious in certain cases where people more or less say, this is a compromise opinion. It's not exactly, something that takes a position and carries it to its logical conclusion. So towards the end of Marshall's tenure, and especially after Washington died, things did get somewhat more factionalized because you had appointments from President Jackson, and also Marshall was, nearing the end of his career, probably didn't have the same abilities to persuade as he had had earlier. He didn't have the boarding house system anymore after Washington died. So you start to see more separate opinions and such. But, the other thing to say about it is they definitely felt a kind of need to work towards enhancing the court's authority as an institution. And that meant sort of subordinating their individual views. Now, Washington was particularly good at that because he wasn't particularly interested in being famous. He was already famous, lived in a famous house, had a famous name, right? So he didn't have a kind of ego that, others might have had. So that might have just been fortuitous that he happened to be on the court in this period.
One other question, if I may. The circuit court set up where the justices rode circuit, how did that work? That's maybe a simpler question, but did John Marshall, for example, come to Richmond to hold court for, was it the Fifth Circuit, or whatever circuit it was then, and other justices go out to other far-flung parts of the country to hold court in the lower courts beneath the Supreme Court?
Right, so each...
How was it set up? How did it work?
Yeah, so basically for most of that period, each justice was assigned a separate part of the country, usually the part of the country they were from, to make it a little easier for them. And then for more time than they would actually spend hearing arguments in the Supreme Court, they would be hearing appeals in their circuit or holding trials as trial judges. Now, they didn't like it particularly, in part because it just meant a lot of travel. And, travel was more hazardous back then, especially if you had health problems, right? And indeed, there were many accidents where the coach would turn over, someone would be thrown, broken arm, broken leg, and so, but part of the idea also was that, well, it would help them be more aware of the law of the United States and the impact of certain legal rules on ordinary people, because they were going to see far more cases and get a better sense of that than the current Supreme Court justices would have, being only in Washington and hearing only a very small number of cases. So there were some virtues of the system, but ultimately, it lasted for about 100 years or so. I mean, then towards the end of the 19th century, it was abolished, and we got something more like the modern system where you just have more federal judges and more specialization.
Thank you very much. Just a quick question. So in the early days of the court, were there so many cases that they had to pick and choose cases like they do today? And if they did do you think that Marshall and Washington basically drove the selection process, or were there few enough cases that they basically heard everything brought to the Supreme Court?
Right. In those days, they heard everything that was brought to them although sometimes they would dispose of it in a kind of summary order of some sort. Now, that said, there were instances in which they did some things that you could describe as a selection process. So, for example, when they were writing these letters to each other about decisions in the circuits, well, if they could work it out at that level, there would be no need really to have a different decision at the Supreme Court, right? You'd already worked it out. So that was part of the function of those sorts of exchanges, to try to avoid or, create some uniformity that would avoid some of those things. Now, there is a famous example, actually, where the selection process or the way in which the case was handled was something that Marshall and Washington sort of took upon themselves, and that is it's a famous case from Virginia, actually called Martin versus Hunter's lessee, where basically, it was a property case, but it ended up becoming a big challenge to the Supreme Court's authority from the Virginia Court of Appeals, which essentially tried to say, hey, the Supreme Court doesn't have the power to tell us what to do, okay, on at least certain kinds of matters. All right, so Marshall was recused from the case because his family owned some of the property that was involved. Okay. However, he very much wanted this Virginia decision to be overruled, so he just decided to write himself the petition for review. And you can find it, it's in the National Archives, in his handwriting, right? Now, in his absence, or in his recusal, Washington was the acting Chief Justice because he was the most senior member of the court after Marshall by this point. And Marshall just handed him the petition, and Washington wrote in a note, okay, basically, and expedited review, and they heard it almost as soon as they could, which was basically within a month's time, because they wanted to quickly kind of, issue an opinion that said, no, we are supreme in cases within our jurisdiction. Now, there's no indication that they consulted with the rest of the justices about this. And there are other instances I document in the book where they kind of took decisions on their own in a way that certainly did not treat the others as equals. And, which would never be tolerated today, right? Or at least if people knew about it, I guess.
Two questions, if you don't mind. On the evolution of the away from procuring opinions, Did he ever comment in his reports on the Virginia Court of Appeals as to the difficulties or how it wasn't practical to continue this English-based approach to delivering opinions?
Not directly. We have some comments from some of the other justices where they relate his views about these things in their own letters to other people. So, you have to take it a little bit with a grain of salt, right? Because you don't know if they were really quoting him accurately. But what his view, as they express it, was dissents that are public diminish the authority of the court and should only be done under exceptional circumstances. Now, it's not as though he never dissented. He did dissent a couple of times, and so did everybody at one point or another, right? But you really had to kind of exhaust every possible alternative before you would get there, and even then, you would only do it publicly if you really felt that either very, very strongly about it or that it was inconsistent with some other position you had already taken, and thus you felt compelled to explain why you were, kind of felt like you had to say something in this particular case. So no, he never directly commented on it. It's just we only know what others said about what he said.
Okay, the second question is, in reading about Marshall, it was, I don't know if it was just rumored or if it was accurate that Marshall would handwrite the opinion and he would hand it to Justice Story and say, here is the opinion of the court, and I'll go find the authority to support it. And my question is, did he do the same kind of collaboration from the standpoint of citing precedent with Washington?
So, Marshall and Washington had a very different view about this. Marshall's opinions, if you read, especially the most famous ones, don't cite any authority at all. He tended to write opinions more like essays, almost that you could reprint in a newspaper and read without the jargon of a typical legal opinion, right? Now, there are advantages and disadvantages to that, right? The advantage is, well, it's easier to read, it's easier to understand, okay, and it makes it sound more like the truth, right? I mean, if I just say it without citing anything, it makes it seem like, it must be obvious. That's why I don't have to cite anything. Okay, so Washington disagreed with that. He felt it was important to cite authority, and he was on the other side of that. He cited a lot of authority. Now, you might say too much, or, his opinions tended to be more kind of, for lawyers. And his view on that tended to be, look, it's important to cite cases because we're trying to build up the authority of the courts. And one way to do that is to invoke their authority, right? And kind of heap praise on them, basically, to kind of build up the structure of the law as being independent of just the personal views of a particular judge or group of judges. Now, you can see that in some cases where they write different opinions in the same case, and Marshall's opinions tend to be much more, let's say, philosophical, in saying this is just how it is, right? As opposed to Washington's opinions that say, okay, Blackstone and, this case, that case, this author, that author. How they work that out sometimes in a compromise might be, well, okay, you really need to have a site here, even if you don't want to have one, or, they found ways to hash that out when they were agreeing on a particular opinion. But, I don't know that Marshall was really asking Story for authority because he didn't really feel the need oftentimes to even cite authority at all.
Thank you. So we know the Marshall Court heard several lawsuits from enslaved folks suing for their freedom. And I wonder if you know where Bushrod fell on that topic. We know Marshall sided with property over liberty in these instances. And I'm more broadly curious about Bushrod's views on slavery.
Right. Okay. So there's two aspects of that question. There's kind of like the Well, there's more than two, but one is his role as a judge, and the other was kind of more his, personal view of it. So, as a judge, Washington often heard fugitive slave cases in Philadelphia when he was writing circuit, because, of course, Pennsylvania was a free state at that point, and many people were escaping from slavery and would then have a case brought in Philadelphia or Pennsylvania. And the book goes through those cases. In every one of those cases, Washington found for the enslaved person and said that they were free. So that's different from Marshall, because one criticism of Marshall is that when those cases came before him, he always found against the enslaved person, and that the person was still a slave. Now, okay, one thing you could say is, well, maybe the law was that's how the law was in those cases. It just worked out that way. It didn't mean anything beyond that. Given the number of cases, that's a little hard to say. That said, Bushrod Washington was not a particular, fan of the Fugitive Slave Act as it was written. He thought it was, basically not helpful enough to slave owners. And he said, well, but his view was, well, I can't do anything about it. That's up to Congress. I have to enforce the law as it is. Okay. That, though, didn't lead to any sort of thought that he wanted to really change the law at all, right? Now, so, okay, that you could say, well, he was being a judge, and that's it. Now, his personal view of it, he kind of thought of himself as a moderate, which meant, gee, slavery is terrible. I hope that we can do something about it someday, but I don't know what that is. I mean, there was one letter in particular, a draft letter I came across at Mount Vernon, where he kind of explained this at some length, like, well, yeah, but if you were to abolish slavery, what would happen to agriculture? And gee, well, we really have to think about that, and I don't know, and I think it'll happen someday, but, like somebody smarter than me, you'll have to figure this out. Now, some of that you could say is a genuine sort of someone trying to think through the problem, but you could also say it's just sort of a cop-out, that it was sort of like, okay, well, hey, I don't have to deal with it, let somebody else deal with it, which was kind of what others in that era tended to say, especially those who, owned a number of enslaved people. He was also criticized because, unlike George, he did not free anyone in his will, and he more or less told all the enslaved people at Mount Vernon, I'm not going to free you. Because apparently, at some point a rumor kind of went around, oh, well, okay, because George Washington freed people in his will, that means that Bushrod Washington will do the same. And he gathered them all together and said, that's not true. I'm telling you, that's not true. I'm not going to do that. So it's, and when he was criticized for that in the press, his response was very defensive and kind of the view of, well, just because George Washington did it doesn't mean I have to do it. I'm my own person. Almost in a kind of resentful sort of, hey, I'm tired of being compared, to a standard that I'll never meet kind of thing. But anyway, so, as a judge, okay, he applied the law fairly, I think it's fair to say. As a person and as a person who was a slave owner, no better than any of his contemporaries, and maybe a little worse.
Well, thank you so much for all coming out today. Hope we can maybe continue the conversation in the lobby. Let's give our speaker one more round of applause.
Thanks. Thank you very much.